Hi everyone, I'm Yu Lei, Corporate Counsel at LegalPad. It's been a busy week and LegalPad is here to keep you informed on what's happening in U.S. immigration. Let's get started. Update number 1. Federal judge invalidated regulations that increase H1B wage requirements. As background, the Department of Labor published a rule in October to increase wage requirements for a handful of visa categories, including the H1B. The rule took immediate effect and the higher wage requirements made it harder for U.S. companies to sponsor foreign workers. Several lawsuits were filed to challenge these new regulations. The good news is that a federal judge recently invalidated these rules with immediate effect. What does this mean? Well, what this means is that the government will revert back to the lower wage requirement, and this will give companies, especially small and mid-sized companies, more flexibility to sponsor foreign workers for H1Bs and green cards. Specifically, starting December 9, 2020, the Department of Labor will revert to using the lower wage rate data for labor condition applications, which is part of the H-1B petition. On December 15, 2020, the Department of Labor will use the lower wage data for prevailing wage determinations, which is part of the employment-based green card process. And employers who receive prevailing wage determinations under the higher wage data may ask the Department of Labor to review and reissue the determination. The government will likely appeal the court's decision, and LegalPad is closely monitoring for updates. Update number 2. Federal judge bars enforcement of the public charge rule in several states. The government wants to expand the definition of who qualified as a public charge, meaning someone who is likely to rely on public assistance. This is important because if you're considered a public charge, this could then negatively impact your eligibility for a green card or status in the U.S. Last month, 7th Circuit Court issued a decision to allow the government to continue implementing its public charge rule nationwide. But more recently, another federal court just issued a ruling narrowing the scope but barring the government from enforcing this rule in 18 states and the District of Columbia. This is likely not the final decision because the public charge rule has been going back and forth in the courts for months. LegalPad will continue to monitor and provide updates. Update number 3. New DACA applications and DACA-related advanced parole applications will be accepted. DACA protects eligible people who came to the U.S. as children from deportation and provides them with U.S. work authorization. The government wanted to restrict DACA, but a federal judge just ruled that the Department of Homeland Security must accept first-time requests for DACA, renewal requests, and advanced parole requests. Plus, DACA work authorization granted for only 1 year has been extended to 2 years. This decision is a significant step towards the DACA program being fully restored, and President-elect Biden has stated that he supports DACA. I hope you found these updates helpful, and I'll see you next week.